The Committee on General Laws will come to order. Madam Secretary, please call the roll.
Representative Cornejo.
Present.
Matthews. Carpenter. Anderson. Arthur. Basie. Cross. Evans. McCreary. Meredith. Raber. Schroer. And Taylor.
All right. I don't think a quorum has been established, so we will hold off. I know a lot of our members are over in the Rules Committee, so when they get done, come over here and we'll go into executive session. But in the meantime, just a couple housekeeping. Senate Bill 590 has been recommitted to the Speaker's office to be referred to a different committee, so we will not be hearing Senate Bill 590. With that being said, we will start with Senate Bill 666. Senator Andre, you may proceed when ready.
Thank you, Mr. Chairman, members of the committee. For the record, Bob Onder, representing Western St. Charles County, Senate District 2. Thank you for the opportunity to present Senate Bill 666, the Small Business Franchise Protection Act. The background for this bill is that in 2015, the National Labor Relations Board dramatically changed the rules for American small businesses. The board replaced a clear, bright-line rule as to who is and who is not a joint employer with a vague, multi-factored test that could result in confusion and increased litigation. With this change, small business owners who own franchise businesses could be held jointly liable with a brand name franchisor if the government alleges employment law violations, and vice versa. Franchising has been a critical part of the American small business landscape in the United States since the mid-19th century, when Isaac Singer invented the sewing machine and created franchises to distribute his new product. A local business, a franchisee is typically a small business owner with one or more local businesses under the brand name of the franchisee. The franchisor, by contrast, is a larger enterprise that focuses on product development, brand management, and marketing. The key to franchising has always been the distinction between the franchisor and franchisee as separate legal entities. In Missouri, the economic impact of franchising is enormous, with 17,000 businesses paying $6 billion in payroll to 170,000 employees. This bill simply makes it clear that the traditional direct and immediate control standard for joint employment is the one adopted by Missouri. 17 states have adopted similar legislation. The perfected version of this bill adds in Senator Schatz's professional employer organization bill, PEO bill, a bill, of course, which you, Mr. Chairman, are very familiar with. It passed the Senate 28-3, and your House version passed the House, I believe, 130-3. I'd be happy to take any questions.
Yes, thank you for making your great bill even better by adding my language.
Of course. Thank you.
Questions of the bill sponsor? Representative McCreary. Proceed.
Good evening. So, not that I expect you to know everything going on the House side, but is the language really pretty similar to what we passed out of the House?
The PEO language is pretty similar. I'm not sure I could say, Representative, identical. I know there were some changes between Senator Schatz's introduced version and the perfected version. Mm-hmm. Now, the Senate Bill 666 part, the joint employer liability part, that's new language. Representative Schroer is my House handler, but I don't believe a Senate version of that has been filed.
Okay. All right. Very good. Thank you.
Thank you.
And just to clarify, the Senate passed their version first, and I was in constant communication with Senate Research that the House version, when passed, did mirror the Senate version. So, further questions of the bill sponsor? Seeing none. Testimony in support of Senate Bill 666. Read when ready.
Good evening, Mr. Chairman, members of the committee. Matthew Panic, Missouri Chamber of Commerce and Industry. I'd like to go on the record in support of this bill. We do feel that the direct control test is more appropriate at the federal and state level. And as Senator Onder mentioned, 17 states have taken up similar action already. We're hopeful that we can just bring clarity to the state's employers so that they can continue in the franchise model as they've done for decades now. So happy to answer any questions.
Questions? Seeing none, thank you very much for their testimony and support. Be sure to fill out witness form. Proceed when ready.
Mr. Chairman, members of the committee, thank you for the opportunity to appear before you tonight and to testify in support of the Professional Employer Organization, or PEO, provisions contained within Senate Bill 666. My name is Melissa Kelly, and I'm here on behalf of the National Association of Professional Employer Organizations, or NAPIO. We are the National Trade Association of the PEO industry, and here in Missouri, our footprint includes 75 members who report doing business in the state and over $500 million in worksite wages. PEOs generally provide HR services to small businesses, and the average PEO client has between 10 and 15 workers. As was previously mentioned, the PEO provisions in Senate Bill 666 are identical to what was passed by this committee and the House by way of House Bill 1656 and House Bill 2075. And these provisions create a framework which we believe will benefit all parties involved and provide operational certainty. As a result, we believe that its passage will be of benefit to small businesses, their employees, PEOs, and the state. For those reasons, we'd respectfully request favorable action on the bill. Happy to take any questions.
Thank you. Any questions? Seeing none, thank you very much for the testimony and support. Seeing none, any in opposition? Seeing none, any for informational purposes? Seeing none, Senator, any closing remarks?
No, thank you, Mr. Chairman.
Thank you. That will conclude the public hearing on Senate Bill 666. Did I see Senator Crawford walk in here? Oh, there you are. So we will now move to public hearing on Senate Bill 951. Senator Crawford, you may proceed.
Thank you, Mr. Chairman, members of the committee. For the record, Sandy Crawford, Senate District 28. Thank you for the opportunity to present Senate Bill 951. This bill is dealing with hospital regulations, and it does a couple of different things. First of all, current law just allows hospitals to expand on tracts of land that are either adjacent or across the street. This bill would expand that premises definition to include property that's catty corner, diagonal, however you want to say it, as well. In addition, this bill will allow state regulations to automatically update when federal law changes when dealing with conditions of participation, or COP, that hospitals have to meet. And this is regulations dealing with Medicare. Our hospitals have to abide by those rules anyway. The problem that we have right now is that federal law changes. Takes state law about 6 to 9 months, or state regulations to change. It takes about 6 to 9 months. So our hospitals are kind of caught in the middle. Federal law says one thing, state law says another. This bill would simply say that the state regulations are going to change when the federal regulations do change. I'll be happy to answer any questions. One final thing I wanted to mention, this bill had 0 testimony against it in the Senate committee. It was voted out 5-0. It also passed out of the Senate 33-0. I'll be happy to answer any questions, or I have some really good witnesses behind me, I think.
Wasn't there a companion House bill? Did you already mention that?
Yes, I believe Representative Bonden had that bill, and I forgot to write down the number, but yes.
Yeah, that's what I thought. That's what was jogging my memory. Further questions for the bill sponsor? Seeing none, testimony in support of Senate Bill 951. Should a fellow witness form proceed when ready?
Thank you, Mr. Chairman and committee members. I'm Sarah Wilson. I'm Vice President of Clinical and Regulatory Affairs with Missouri Hospital Association. I'm here to testify in support of Senate Bill 951. As Senator Crawford noted, this bill allows our hospitals who have to meet the CMS conditions of participation for hospital regulation to be able to work in concert in real time and keep our state regulations the same as those that we're abiding by CMS, and also addresses our hospital premises issue. As Senator Crawford said, we are able to license our hospital premises opposite side of the street or adjacent, but not a catty cornered across one intersection. This creates significant burden for our hospitals, especially in the area of pharmacy. management services, because if they're not on hospital licensed premises, we have to create duplicate compounding units, and it's very expensive, costly, and also presents a patient safety issue.
Any questions? Seeing none, thank you very much. Further testimony in support of Senate Bill 951. Seeing none, any in opposition? I guess we're back to support. Proceed when ready.
Yes, sorry. Jessica Pabst on behalf of SSM Health. We'd like to thank the sponsor for bringing this forth and go on record in support.
Any questions? Seeing none, thank you. Further testimony in support.
Kathy Harness here on behalf of St. Luke's Health System in Kansas City and in support of the bill. Thank you.
Questions? Seeing none, thank you very much. Further testimony in support. Seeing none, any in opposition? Seeing none, any for informational purposes? Seeing none, Senator, any closing remarks?
No, just thank you for the opportunity to be here tonight, and we'll appreciate your support. Thank you.
Welcome back home. That will conclude the public hearing on Senate Bill 951. Moving on to Senate Bill 909. Senator Dixon, you may proceed when ready.
Thank you, Chairman. Members of the committee, Bob Dixon, District 30, to present for your consideration Senate Bill 909. This is the Missouri Fiduciary Access to Digital Assets Act. This is essentially the same bill that the House voted out and sent to the Senate, which was House Bill 1250, Dean Plocker's bill. Basically just allows a process for essentially the same type of process that a pay on death or transfer on death would allow, or allows rather, for bank accounts, so that somebody can access those digital assets. Be happy to answer any questions.
Thank you. Any questions of the bill sponsor? Seeing none, thank you. Testimony in support of Senate Bill 909. Proceed when ready.
Mr. Chairman, members of the committee, Eric Wilson on behalf of the Missouri Bar. We'd just like to go on record in support of this bill, and I'm happy to take any questions.
Questions? Seeing none, thank you. Further testimony in support of Senate Bill 909. Seeing none, any testimony in opposition? Seeing none, any for informational purposes? Seeing none, Senator, any closing remarks? Thank you. That'll conclude the public hearing on Senate Bill 909. Moving on to House Bill 2569. Representative Frederick, you may proceed when ready.
Thank you, Mr. Chairman, and thank you, committee, for a late night hearing. House Bill 2569, and I'm actually going to be referring to the document that ends in .02C, which is a sort of the latest iteration. So vacation nightly rentals are a significant source of revenue in our state. It brings in about $310 million a year, and it's a very active practice in our vacation tourist areas at Lake of the Ozarks and Branson. You are very familiar with this concept because you've heard a couple bills in the past regarding this. This one was actually constructed with a lot of input from the folks that own and operate these facilities, and with sort of attention to the areas that they see threatening to the current and continuing operation of these. So I'll be pretty quick. We do have folks that are coming for testimony because of the late night. They went out to grab a bite, and they'll be coming back in here shortly. So the summary of 2569 is that vacation nightly rental owners do agree to pay the taxes that are paid by hotels and motels. They will pay their sales taxes. It's not happening universally right now. I think that's sort of spotty enforcement and spotty compliance, but this bill would require those taxes to be paid. In addition, there is at least one area of our state that has sort of a tourism tax. It's a lodging tax that goes toward development of tourism. And these folks also are not resisting paying that, but they would like to have some representation on the board that decides how those funds would be used. So another section, another component of 2569 is that political subdivisions should not be authorized to outright ban vacation nightly rentals simply because they are vacation nightly rentals. And probably the crux of one of the, I think in my mind anyway, one of the main differences between this bill and the other bill that you heard last year and this year deals with regulations. So I view this as part of the sharing economy. And to allow over-regulation at the municipal or county or fire district level would put this very sort of nascent business, this entrepreneurship, in jeopardy of being snuffed out. In the past, regulations, first of all, there was a previous bill that would allow banning, but I think there's pretty good acceptance now of the concept that you can't really do that. I mean, it's not constitutional to just outright ban it. So the question then becomes, how do you regulate them? And the difference between reasonable regulations, which in the past was described in the other bill as basically anything that doesn't put these folks completely out of business, and the difference between that and what my proposal is that it should be that the government should have to demonstrate a compelling governmental interest for the public health and safety, and it should be narrowly tailored and use the least restrictive means. So let me go into that just a little bit, and I provided, I think you should have in front of you copies of two articles. One that the title is "The Unexpected Reason Panhandling Bans Are Being Struck Down Across the Country," and the other one deals with a Supreme Court case of Pennsylvania. No, that was just a lawsuit in Pennsylvania about Uber. So let's talk about the panhandling bans. The Supreme Court ruled that outright bans of panhandling is a violation of the First Amendment, and this is happening all over the country. And the legal tenet, and those of you that are attorneys, maybe you can enlighten us on this, but that municipalities that are going to regulate this have to show a compelling governmental interest and use a narrowly tailored remedy. So the idea would be you can't say that you can't ask for funds and do the typical panhandling type activity, but for the public safety you could say that you can't approach vehicles in the street. You can't be walking through the streets doing this because that's a public safety issue. But it is protected that you should be able to ask folks for money and hold your sign up. So it's my opinion that if the constitutional protection of panhandlers requires a compelling governmental interest and narrowly tailored, then our hardworking entrepreneurs who are the lifeblood of this tourist economy that's blooming now, they should be afforded the same protections in terms of their constitutional rights under the Fifth Amendment for property rights. The other article, so that article on the unexpected reason with the picture on the front, that's the Supreme Court. This other one, is dated March 12, 2018, is about Pennsylvania suing Uber. And I'll just summarize this for you, that this deals with the definition of reasonable. Actually, in this one, it's unreasonable. But there was a data breach by Uber where a whole bunch of people had their data taken and hacked, And Uber had a requirement under state law to notify those individuals whose data was hacked without unreasonable delay. So Uber went on for over a year hiding this and paying the hackers off to keep it quiet. And the state of Pennsylvania said, wait a minute, you were required by state law without unreasonable delay to notify all these people. So this article goes to point out the danger, and there's some other state representatives, Wist, who is a state representative, that reasonable puts the onus on the individual who has been wronged by state law to come, or maybe municipal law, to come and prove their case in a court. And we've gotten opinion from attorneys that it could cost you $50,000 to $100,000 to fight a municipality to try to say what's reasonable and what's not reasonable. So I think this whole argument about reasonable regulation, reasonable is too subjective and allows the municipality or political subdivision to simply enact a regulation and call it reasonable and then force the individual who is subject to a whimsical regulation to prove that it's reasonable or not reasonable. So I think those two cases, the fact that the Supreme Court has ruled, at least in First Amendment rights, that government should show a compelling governmental interest and it should be narrowly tailored, and the fact that reasonable is not really, it's a very ambiguous thing that can be abused. So that's the crux of it, but there are a couple of other things included in the bill that a homeowners association cannot consider a vacation nightly rental a commercial enterprise, because that in most HOAs would prevent you just on the face of it from renting your home out as a vacation nightly rental. Which I'd also say that there's no regulation or rule against if you own a house, and I lived at Lake of the Ozarks in a community in a neighborhood that had a lot of second homeowners. And they would have their relatives down, their friends down, maybe fraternity down, and it was not being used as a VRBO, but there were a lot of other family members and other friends using it, and there was no prohibition against that. And I think that's a common occurrence now. But one of the last provisions that if an HOA is going to ban the use of your property as a vacation nightly rental, but it wasn't banned when you bought, that should take a unanimous vote of the HOA. Because a lot of these folks may have bought with the idea, especially a second home, that I can't really afford it, but if I can rent it out for a weekend a month, that can help me make my mortgage and it's all good. But as soon as they get the rug pulled out from underneath them, they've lost part of their property rights. A taking can be taking the whole property, or it can be reducing the use of your property by 20% value, and that's a taking also. So with that, let me close with this. Our property rights need to be protected. Fifth Amendment's not all about claiming the Fifth in terms of testimony. It also has to do with your property rights. And there's no big lobby that's going to come to the aid of the people. It's up to you and me to come to the aid of the people. I'll stop with that. I've got folks that have traveled a great distance to be here to testify, so I think I want to give them the opportunity.
So, I guess I'm just, where are you drawing the line? Because you're getting involved in private contracts between a HOA and an individual, so I guess, how did you determine where you were going to draw that line as far as when you get involved in private contracts and when you don't?
Well, you would reduce the person's property value by a substantial amount. I think that's a taking. I think it's unconstitutional to let them buy it with the idea that they can use it for that purpose, and then in the middle of that, you revoke that. When I owned property down at Lake of the Ozarks.
Before you go, you revoke that. What part? What's being revoked?
Well, when you ban the use of it as a vacation nightly rental, you have revoked that part of their property rights. Because the property is then worth less money once you do that.
Okay, sorry to interrupt you.
No, that's okay. That's okay. I want this to be a free and open interchange. So I lived at Lake of the Ozarks in a subdivision that had certain rules in place when people bought, and we had a very expert real estate attorney advise us when we decided to change the clubhouse to a home because it was too expensive to maintain, a lot of different things. But he told us that it was required that we would have unanimous vote to do that, because when people bought, they were told they had a clubhouse to use. And so if you're going to change that, it's not just the majority that changes that. Everybody has to say that's okay, because it reduces the value of your home if you no longer have the use of a pool and a clubhouse. And I think there's an analogy there.
Okay. Further questions? Representative Meredith.
Okay.
Proceed.
Thank you. So I want to follow up on that. So I guess when you also move into an HOA, you move into a place where it has certain bylaws on how it gets changed. And that might include if something new comes into existence, like in this case, vacation rentals, nightly rentals, that there's an understanding in the bylaws that that there may be new rules established with various thresholds. So you're saying in the one that you moved into, there was a unanimous requirement. But if you move into one that doesn't have a unanimous requirement, don't you also know that you're accepting that possibility that rules may come into place that weren't there when you moved in?
I think it's one thing to talk about weekly trash collection or biweekly trash collection, but it's another thing to talk about a substantial reduction in the value of your property based on a broken promise.
So I guess what I'm wondering, though, is I think there may also be neighbors who feel that there is a substantial value in their property if they have neighbors who are now no longer stable neighbors but are transient guests coming in and out every other night.
I think that's... Well, go ahead.
Well, I look, I don't love HOAs, actually, and I don't really have any in my district, but I have a little experience with some of the fights with them as an attorney. And, I mean, I went to a long meeting where a whole neighborhood was up in arms over a vacation rental that had shown up in their neighborhood that was having people out in the pool every night. There would be, maybe 10 people staying there in a night. Because they rented as a group, and that's not what their expectation was when they moved in. They didn't move in next to a hotel; they moved in next to neighbors. And so there was a new concept that came into place, and that was this vacation rental approach that didn't exist when the rules were first established in their homeowners association. I have a problem telling that homeowners association that they can't change their rules the same way that they always have been able to when everybody else moved in as well, because there are, of course, two people's property rights involved here, right?
Yes.
Or more than that.
Yeah, right. Of course, I think the folks that object to having a panhandler in their neighborhood too have the same thing as I don't like this because I don't like these panhandlers running around. But the Supreme Court says you can't just ban them. So I mean I think it's a similar situation.
I don't see in your article where it talks about why they can't be banned. Actually,
okay,
I'm not sure it gave that page.
2. In Reed versus the town of Gilbert, the court ruled that government regulations curtailing free speech have to be as narrow as possible and must fulfill a compelling governmental
Did we get
interest.
that page? I think we didn't get that page.
Oh, really?
Yeah.
I'll see that you do.
Okay.
So just on page 2.
Yeah, I was looking at this trying to figure out where it talked about what you were talking
with
about.
the picture on the front of it? Do you have
Yeah. No, I'm looking at the right article.
Just
But
flip it.
our second page starts with city councils often enact these bans.
Oh,
Yeah.
you don't have page 2. Sorry. We'll see that's correct.
That's okay. I'm curious to see that. But I do think this is a pretty different concept because we're talking about a place where you moved in knowing you're subject to an agreement that all the homeowners are part of.
But that's
and in this case, if you know that your homeowner's agreement has provisions that allows rules to be established and changed with a majority, I have trouble as the state stepping in and telling them they can't do that.
So
It's interference with private contract, right?
So if you bought a home, well, it's interference with your constitutional rights, in my opinion. It's a Fifth Amendment right to due process. If you're going to have it's almost like eminent domain.
But it's not exactly a due process. Your property's not being taken away.
Yes,
but there's an argument. If you're saying that it's based on property value, that my property value goes down because I can't use my home as a rental,
Right.
but I moved into a neighborhood that has regulations about how the house can be used. It prohibits hotels. It prohibits all these other things. I'm going in with an understanding that my neighbors actually have a right under a contract to change the rules.
But you may have checked, though. You may have checked to
But
see
but,
that your vacation nightly rental, that your HOA did not specifically prohibit the use of vacation nightly rental.
But
So
it
you bought with that in
specifically
mind.
allowed changes to be made with a majority,
But not to
and
your
every one of you agreed to that when you moved in. And again, if we're talking about due process rights of changing the value of your home, if the vacation rental is impacting the value of my home next door, well, that argument works both ways. And so for me, I have trouble stepping in and saying one side is allowed to have that argument and the other side is not, and we're going to step in as the state and preempt their local contracts. They're private contracts between homeowners that you bought into when you moved into the neighborhood.
That's true, but it affects your fundamental property rights. It's a constitutional right. It's your Fifth Amendment
Well,
right.
I'm not sure. You don't have a fundamental right to use your property as a hotel, right?
But you're using it for dwelling for individuals. I mean, it's not like you're operating a zoo where you're bringing animals in. You're operating it for the
that's
dwelling.
essentially
it's
a commercial
residential dwelling.
but
It's people coming in. It's just different people.
But it's a commercial operation
so
happening
the neighbors
there,
are going,
right?
well, there are different people coming in here. Oh, we can't have
So
different people.
we don't move into a residentially zoned neighborhood necessarily thinking that our neighbors next door are going to be using their property for profit. with other people residing in it for the night. We
But
we
long-term
move
rental,
in.
they do that all the time for long-term rental. If it's over 30 days, it's all
Agreed,
fine.
but
They
then-
don't pay sales tax or anything.
But then you know that you're understanding that it's going to be a stable neighbor that you're getting to know. Some people like neighborhoods to be a place where you know the people that live next door to you,
Different
and not that
people.
you have a hotel next door to you.
Yeah.
Look, I actually may support your bill. I'm just trying to walk through my concerns about HOAs. Sometimes have higher standards than I'm okay with. Like, I don't like a lot of rules HOAs have. I don't think I would ever be willing to move into one. But I also have some fundamental appreciation for their ability to have those contracts. And I'm not sure where we draw those lines, and I'm not sure this line is
How
quite
did you feel
appropriate.
about the example that I gave about changing the clubhouse and pool into a private residence and that requiring 100%?
I think that depends on what the bylaws of the HOA were.
So
If the
I mean-
HOA said you have a clubhouse, and in order for that to change, it's got to be unanimous vote, well, that's what I knew when I moved in.
No,
If the HOA has bylaws that say we can establish new rules and regulations based on a majority vote, then I knew that when I moved in. It all comes down to what the contract is.
Yeah, but it's about protecting the minority. I think you'd be really sensitive to that because the 49%.
I would think you'd be interested in protecting the right to private contract. So sometimes we're not always in line with perfect principled concepts because
Right,
reality is gray, right?
You bought a house and it had a pool and a clubhouse with it, and then 51% of the people said, no, we don't want that anymore. You'd be okay with, no, I just lost the use of that.
Depends what the agreement said. Again, like if I move in and the contract says that this can be voted on, a majority can change the public use of a public part of the neighborhood, well, then a majority can change the public use of the public part of the neighborhood.
Well-
I mean, that's sort of what we do when we don't live in HOAs, when a majority vote can change the way a property is zoned down the street.
Well, the experienced real estate attorney that we had from a very large group in St. Louis expressed to us that we would expose ourselves to significant legal risk if we did this and didn't protect the rights of those who bought with the idea that they would have a clubhouse and a pool to use. That's
Interesting.
all I can tell you.
Well, I appreciate that. Thanks for the conversation.
Further questions? Representative McCrary. Proceed.
All right, so most of my district is made up of private subdivisions, so they're all governed by HOAs and with elected officials and such. So my question has to do with the last page of the bill, page 22, lines 9 through 11. You talk about unless the prohibition was included as a condition of the property title. So
Yeah, at the time that the owner bought.
right.
That's
so
kind of related to what we're talking about.
Right. Yeah, it ends in .02H. It was in the stack. So does that mean, though, that when somebody sells their home then, so if your bill were to pass, I think what I'm seeing is that it would be like a rolling type of approval in a subdivision possibly? So like if someone who owned their home for a long time had the prohibition against the nightly rentals, and they sold their house and the prohibition was no longer in place, then eventually all the houses would be phased in? Are you looking at it that way?
I don't think so. I feel that it should be that if you bought a house and there was no prohibition in place, then to change that should take a unanimous vote. But after you have that unanimous vote, that carries on in the future without restriction or problem. I mean, I don't know if I'm making myself clear.
Well, so I'm trying to understand what you mean here. So you're saying that no homeowner association can ban these residential dwelling rentals unless the prohibition was included as a condition of the property title at the time the property owner acquired such property.
Like if a developer says, I'm going to develop this tract of land and none of it's going to be vacation home rental. Anybody that wants to buy, you better buy with that in mind. I'm all good with that. And I think we should be as a state. But if they started it and didn't have that.
I would say most of the subdivisions in my district already have that in place in their bylaws as part of their private homeowners association. So it sounds to me that
if that was a part of the original offering, then those folks would not be subject to this.
Okay, so your bill doesn't go back and try to...
I see what you're saying. No, if they did that when it was originally offered, and you're like, you get into this.
We already have, in the subdivision I live in, it's private, I've been a trustee there, we already prohibit that. So it sounds to me like we would be okay if this bill were to
I believe
pass.
that's to be the case. You know, one other thing, Mr. Chairman, could I just add one little caveat? And it's not a part of the bill, but it is something that I've had discussions with a number of stakeholders about. The possibility of carving out our tourist areas, Branson and Lake of the Ozarks, are different communities with different needs, different experiences. We have a lot of transient people coming, a lot of tourism coming, and I think there's much less resistance to this idea. In fact, there's a lot of support to this idea in those two areas. So if it were the committee's judgment that it would be best served to allow these provisions, or most of these provisions, whatever the committee desired, to apply to our vacation areas and to have the rest of the state covered by the other bill that you've heard in this committee, I'd be fine with that. I think there are special needs in our tourism areas where this is really common and it's not feared at all. I mean, when I lived in my subdivision, I had people coming and going all the time, and it's like it's part of the lake life, whereas it might not be as much a part of Clayton, say, or whatever.
Well, and I'm basing this on door knocking in my district. There are countless subdivisions that I can't even get in because they're gated with security. I can't imagine if these homes were to become nightly rentals that you would be giving out the security code to some gate, and it really complicates security.
I understand that.
Yeah,
There might be a case to be made for,
and
making it
during,
applicable to different areas.
During the eclipse, I was desperately looking around for places for people to stay, and when I went on some of these different sites, it was very obvious that there weren't any rentals available, nightly rentals in my district, but if you just went a little bit east to University City where they're permitted, there were all kinds of homes that we could rent and did. So, so I think, in St. Louis County, you can very easily find something within a 5 or 10 mile range. I think I like this part of your bill just because I think it's respectful of the homeowners associations that already have things in their bylaws. So thank you.
Right, thank you.
Further questions? Representative Taylor.
To inquire.
Proceed.
So I had some of the same issues or questions in regards to the homeowners association that Representative Meredith had, because I don't believe that they're taking away that individual's right to own a home. I do think though that they should have. I mean, it's a homeowners association. You knew going in, like Representative Meredith said. That it could change while when you sign, and that could be for anything. Let's say someone owns a chop shop, and you have a couple cars out in front of your place, and then the homeowners association decides to change the law. Well, you knew going in that they were going to change the law, and now you can only have 2 cars out in front of your house. So I do think that there's an issue with saying that it has to be 100%. So
I think my response to that is we're not talking about having a chop shop. We're just talking about people coming and staying in the house. And I think the only difference is...
Oh, but it's a business
those are
just like
different
this
people.
is.
Yeah, but it's not operated in the typical way that a business is. And you can't use it for other commercial activities. It's the activity of having people come and reside in the house, just like it is when you're home. It's just different people. So if you have this feeling like, oh, those people are different, well, okay, then I see you. But
right, but to use the argument that it's against their Fifth Amendment right to own the home, I don't think is valid because they have the opportunity to own the home and to use the home. They can't use it for these purposes, which is a commercial aspect.
But you see, when we did the Uber bill, and I see the sponsor up there, we did not consider the Uber driver's car to be a commercial vehicle. It was a private vehicle. It was specifically called out in the legislation that it should not be considered a commercial vehicle.
Sure.
And so, I mean, this is still just allowing regular people to come and live in a house, and they're not.
But they were also subject to the tax and ensuring that the taxes were taken during the ride. That the company that oversaw that would take those and collect those taxes and then remit them.
Which this bill does. So the analogy continues.
So it requires them to be remitted at time of sale or at time of use?
If it's a facilitation platform, then the facilitation platform has to require as a term of service participation that they will collect and remit the taxes. And the owner has to agree to that, and the transient guest has to agree. There's no effort to try to skirt taxes in this.
Sure,
unless
and I'm
you
not saying
consider
there is.
Okay.
I'm just curious. I didn't know how that applied to.
And the other thing just about the property right thing is that, taking, in my view, and I'm no legal scholar, but taking the property outright, okay, that's forbidden, But taking a portion of it, I mean, if you reduce the market value of it by 20%, that's the same as taking 20% of your property, in my view. I mean, it's a partial taking.
Yeah. I just had a couple more questions. So I know that you're concerned with the other legislation. You had concerns with the reasonable regulations clause, right? Saying that's a little vague. In your language, instead of using reasonable regulation, you use compelling government interest and narrowly tailored. Are those defined? Because if your concern is that reasonable regulation isn't defined, is yours defined?
Those have a much more acknowledged meaning in law than reasonable. Reasonable is
well, we
what
use a
you do.
reasonable regulation in a lot of
I know
areas
we
of
do,
law.
and we shouldn't. You're right about that. It's too ubiquitous.
Well, I don't want to point this out, but you had a bill the other
I
day
know
that had it 17 times in there.
And Representative Barr has pointed that out to
Okay.
me, and I will never do it again.
Okay.
You're right about that. We use it too much, and the Pennsylvania case shows that. But for attorneys in the room, I mean, I believe that those terms have a more defined meaning in law than reasonable does, even though reasonable is much more common.
Yeah. Okay. Okay. Thank you, gentlemen.
Further questions, Representative Meredith? Proceed.
Thank you. Sorry to come back. So first of all, I completely agree. It's a clearer standard, I think, in the courts than just plain reasonable. I do have to challenge your contention that a vacation rental nightly is just the same as somebody living there. I mean, there's a reason that we regulate hotels differently than a multifamily. Because it's in and out guests. It changes nightly. There's a lot less ability to control if a resident is a nuisance, because if they're a nuisance today, but they're not going to be there tomorrow, there's a whole lot less you can do to go after the people that are the nuisance. Whereas if you're dealing with somebody who's there every day for an ongoing period, you know what you're getting and you know how to respond to it. There are other factors that come into play when you have lots of people coming in and out that require more regulations, right?
Of course, the nuisance thing normally would, I mean, if my neighbor is not a vacation nightly rental, has got 100 decibels coming out of the backyard, I mean, I'm going to call the police right then and there, and so the same thing should apply here.
Right. No, and I use nuisance as one example of many, but there, like I said, do you think that hotels should be treated exactly the same as an apartment multifamily unit? Or are they different?
Well, I mean, different in terms of safety requirements, because you've got a whole bunch of people in a big building that requires an elevator to get
Well,
from
but
floor
that can
to
be true in a
floor.
lot of multifamily apartments as well. But they're different because they're in and out. They're transient guests. There is a different level of concerns associated with transient guests and a different level of predictability for a neighbor living next door. So that kind of brings me to the next question, though. HOAs that don't have prohibitions because this thing didn't exist 10 years ago, we'll say. And most of these HOAs, their laws have been in place, or their agreements have been in place since 100 years ago. Some of them, they didn't contemplate this, but they may have prohibitions on multifamily units. They may have prohibitions on hotels. They may have prohibitions on conducting a business. They may literally just have a prohibition on conducting a business. And so, if you move in knowing that you're not allowed to conduct a business out of your home here, and then we discover this new business model that is sort of somewhere between residential and business operation. And the HOA says, well, we're going to take a vote whether or not our homeowners are okay with this. I'm not sure why that should be something that requires a unanimous, because they're just clarifying in some ways what their existing rules are when those existing rules didn't contemplate this new business model.
I mean, I don't know how to characterize a response to that other than keep in mind that 30-day rentals are not subject to any of this. So we're just talking about go under 30 days, and now you got all these special rules.
Yeah, well, over 30 days it becomes a rental, right?
And you don't even pay taxes on that. So these folks that are agreeing to pay taxes, even though the guy that's renting for 31 days pays none of that, doesn't have any of this headache, I mean, I think
so generally speaking, the kind of people that come in for 2 nights are going to be a lot different than the kind of people that are staying for a month.
What kind of people
right?
are they that come in for 2 nights?
People on vacation.
I mean,
usually that's more of a vacation trip.
It could be a business trip. Could be a meeting.
Yeah, but that's a little different than becoming a resident for a little while you're there, right?
You still have to abide by the law. I mean, I just
Agreed.
don't see it.
Well, we're going to go back and forth on that concept. But then the last one I wanted to ask, just in follow-up to Representative McCreary's question. So the way I read this, the prohibition was included as a condition of the property title at the time the property owner acquired such property. So if I have one homeowner that has started a vacation rental business, and they bought that property after my homeowners association 5 years ago added a prohibition on vacation rentals, they're not allowed, or we can stop them from doing that.
Right.
But does that mean that their neighbor 5 doors down, who's been there for 10 years, who had the property prior to the HOA having that agreement, would be able?
You go down a legal road that I'm not real
So
sure
the way I
of.
read this, it looks like two different property owners in the same HOA would be treated differently
I
based
don't-
on whether or not they bought their property
I
before.
think that's the case. I think that if the entity didn't ban it before the individual who bought and wants to use it that way, then it would take a unanimous vote to
Well,
prohibit
this says that they can unless the prohibition was included as a condition of the property title at the time the property owner acquired such property. Which property owner are we talking about?
the one that wants to use it as a
Right.
vacation
So
rental.
I'm saying if you've got two different owners in the HOA, one of whom acquired prior to it being included, because again, these things were only contemplated 5-10 years ago,
Right.
but one of them has been there longer. Are they now going to be treated differently under this law?
I don't think so, because they couldn't have gotten to a prohibition unless they had a unanimous
That's
vote.
not true. There's nothing in statute that requires unanimous vote right now. So currently,
I was projecting if this passed.
right, but
So-
we're talking about last 5-10 years.
Okay.
If an HOA 5 years ago passed this, then somebody who was there 10 years ago is not subject to that new rule, but somebody who moved in last year is subject to that new
No,
rule.
I think unless it was done by a unanimous vote, everybody's subject to that.
Well, this is an or the homeowners association adopted the prohibition by unanimous vote.
Well,
It's
but
not
the first
an
case
and.
was it was prohibited from the get-go.
I'm saying 5 years ago, by a majority vote, an HOA passed a prohibition.
No, that's not from the get-go, though.
It doesn't say from the get-go. It's at the time the property owner acquired such property. It doesn't say at the time the
Might be
HOA
right on
was
that.
created.
You
Okay,
might be
that's
right
what I
on
think.
that
And I think that's probably not constitutional, actually. Would be my bet as a statute. But last question, I think that's a concern you might want to fix.
Right.
Last question, you mentioned tourism areas are kind of supportive of this. I think it's a really interesting idea to just apply this to them. If they're really supportive of this, why isn't this happening on a local level there already?
Well, parts of it are. I mean, the part of only treating them as residential for property tax. Actually, there's an individual, I don't know if he's here tonight or not, but ran for assessor based on this issue.
I remember hearing
and
that
was
last time.
elected, and I talked to him just a couple of nights ago at a Lincoln Days, and he has reversed. They were starting to tax him as commercial for property tax, and he ran on and then reversed that.
Wow.
So some of this is starting to happen at the local level, but it's just the case that it's so difficult. There's an individual, I think he may be here tonight, so I should let him speak. But he got a wonderful home that could be a great vacation rental, and I think it's Stone County is saying, no. And it's like, why? And there's no good reason for it other than we just don't want to do it.
I guess what I'm having trouble with, though, with the whole concept that we might just do this for tourist areas, because we're acknowledging that different areas have different needs and different desires in different communities. Why aren't we leaving this to a local decision in the first place so that different communities can all treat this differently based on what their local communities' unique needs are?
I think it is in general the case that local municipalities are more in love with regulation, taxation, and overstepping legal, being big brother than state governments are. And you and I may differ on that, but I'm not of the opinion. Say, for instance, what happened in St. Louis, where the municipalities were running their government off of traffic violations. And I became not so much a fan of local control at that point because I thought they were abusing their population. And so this is kind of the same thing. I think there are some areas where they're over-regulating, not to the benefit of their population, and I think it's incumbent upon us to prevent that.
Thanks.
You bet. Thank you.
Questions? Seeing none, testimony and support. Sure to fill out witness form. Proceed when ready.
I'm Greg Hasty. I'm the presiding commissioner of Camden County. I'm a 45-year surveyor and land developer at the Lake of the Ozarks before that. I'm also a licensed real estate broker for 20 years. And I've effectively been involved in Lake of the Ozarks since Osage Beach was just a wide spot in the road and didn't have a city hall or anything. Obviously, our economy is transforming, and things are different than they used to be even 10 years ago. Lake of the Ozarks in Camden County alone has 45,000 residential homes, of which about 30,000 of them are owned by people who are not residents there. Our entire economy over the 45-year period that I've been involved at Lake of the Ozarks has developed around homes on the Lake of the Ozarks with a boat dock in front of them. A long time ago, there were literally no hotels off the water, virtually none. There was no shopping center. There was nothing. September the 1st, the Lake of the Ozarks rolled up its doors, closed everything, restaurants closed, shops closed, everything closed. There was nothing, dead in the winter completely. You could drive through Osage Beach 150 miles an hour if you wanted to, because there wouldn't be anyone around to stop you. But over a period of time, many residential subdivisions were developed. Condominiums were developed. And at a certain point in time, there were so many residents there that you began to have shopping centers develop, restaurants develop, and around 1980, the Lake of the Ozarks began to really grow by leaps and bounds. Once that shopping was established, once the restaurants were in place, there were a lot of things to do other than just a boat and a house with a boat in it and a boat dock. And because of those things that were available to be done, all of a sudden you have hotels popping up around for people to stay on a short-term basis because you had shopping and restaurants, good place to go. Lots of hotels stay very full because of that. But let me just explain. If it wasn't for all of the residents that were coming and staying in those homes on a nightly basis or a weekly basis, coming down to visit, 45,000 homes with people in them is what supports the restaurants and the shopping. If something occurs to this economy that makes the Lake of the Ozarks owning a home or being able to afford to own a home on the Lake of the Ozarks less desirable, or something should occur that would change the nature of that property from what it is currently, because right now we're doing fine. The potential impact on our economy could affect not only shopping, restaurants, but it could actually affect the hotel industry as well. You have to have those homes with people in them to be able to support the shopping and the other industries that are there, and the hotels that are off the water besides Tanterra and Four Seasons could not exist if not for the shopping and the restaurants and the life that's there. I've been around this lake a long time, and I understand this economy intimately. And nothing in my 45 years has petrified me more than the potential of giving a government the necessary power to come into a subdivision or into my county and say, oh, by the way, we're not going to be able to allow you to do this anymore. If something occurs that it makes the desirability of owning a home on the Lake of the Ozarks with a boat dock in front of it and a boat in that dock, then our entire economy is undermined. And that's why I think you have so many long-term real estate agents and people like that so concerned. We are entirely different than Kansas City or St. Louis or anywhere else. And I'm telling you, this petrifies me, what I see. The potential of having some, and this is the third year for this, honestly, they were literally within almost a day of passing something 3 years ago, and the realtors called me and said, Greg, you've got to go up there. You've got to go up there. And when I looked at the bill that they were about to pass, it literally would have taken every one of those residential homes and put them completely under the same regulations as a hotel, and it would have been a complete disaster for Lake of the Ozarks. Keith has worked really hard, and it's going to be really difficult to have something be perfect for us and be anywhere close to being good for people in Kansas City and St. Louis. But now just think about this. 71% of our homes are owned by people that don't live there, and those homes are, unless they're coming down for a weekend, they're just sitting there unless they're being rented out on a short-term basis. And with regard to the regulation, as a commission, we are trying to address this. We're putting in place provisions where we're going to be able to enact ordinances, and we've got a confirmation from our circuit court and from our prosecuting attorney that we're going to be able to go in there and not just regulate issues with regard to compliance for short-term rental people, but also the homeowners that come down. And trust me, I lived on the lake, and the drunken neighbor was just as big as a problem as the guy that may have been renting on a short-term basis. So I really have an intimate knowledge of what's going on, and this petrifies me for our Lake of the Ozarks. And not only that, but I see the potential, economic potential, to really make this transformative of our economy if we're allowed to have this take place. I'm really not too worried about the hotel industry because I'm going to just frame it like this. When I go to Pensacola Beach for my vacation every year, I rent a condominium for a week, and I pay sales tax and all that. No big deal. If I'm going on vacation somewhere where I'm traveling, I don't even think about a short-term rental. All I do is get a hotel. They are really two different things, and from what I'm seeing, particularly at the Lake of the Ozarks, no question this is true. It's a mutual relationship at Lake of the Ozarks between the existing hotels that are there and the short-term rental housing and the housing that's there, because if those homes are not full, if there aren't people in those homes, then the restaurants and the shopping is going to fail, and if the restaurants and the shopping fails, the hotels are dead. So, I'm available for any questions you want, but I'm just telling you right now, this is the third year I've been up here, and the potential to have legislation passes that impacts us entirely different than the rest of the state, it could be devastating to our economy. And that's why the realtors at the Lake of the Ozarks are so scared over this.
Thank you. Any questions? Seeing none, thank you very much for the testimony and support. Should have filled out witness form. Proceed when ready.
Hi, I'm Jeremy Worley. I'm from Branson, Missouri, and I've spoken in front of this panel before a number of times. I'm the president of the Missouri Vacation Home Alliance, and I'm a vacation rental owner, and I have been since 2008, and I was a realtor then. I actually started my real estate business in 2008, and it was a really, really bad time to start a real estate business. And the only thing that saved me was these short-term rentals. What's interesting is that a lot of the people in Kansas City and St. Louis who don't want short-term rentals in their backyards will come to my hometown, and they want them in mine. But I'm okay with that because our economy depends on it. And I'm here to speak not just for myself, but for the hundreds of people that are part of my nonprofit advocacy group, because we don't feel like we've had a voice up to this point. And so they've sent me with a few messages, and I just want to share a few of them. This is a book that my kid wrote. It's called The Life of Ellis Worley by Ellis Worley. And what's really interesting about this book is it starts with him being born, and it goes on and it shows him growing up and being a dad and having a kid on his own, which is such a heartwarming thing to see as a dad. And it was, let me tell you that 3 years ago it was a totally different story, the things that he was drawing, because my wife was working a retail job, and she was gone every night. And here I am trying to run a real estate business and stand up for people's property rights and show people how vacation rentals can truly help their lives and change their the financial state of their lives. And it took me a while, but I finally was able to scrape enough money to buy a few of them and have my wife manage these full time for us. So now she's able to be at home with my son, and that has changed my life and his tremendously. Another quick example, and I just want to speak on behalf of people that couldn't be here tonight, is this. This is an invoice that I paid to a gal named Becky Groman. And Becky Groman is a business owner, and she cleans multiple properties. This is an invoice for $850 that I paid her for just 2 properties that I own just this month. And the interesting thing about Becky is that she broke her back a few weeks ago, and she's unable to clean properties. But she was able to hire 7 people to work for her, thus creating 7 jobs in Missouri, and she's a small business owner. And she was able to stay afloat with the business that she ran as a subsidiary of this vacation rental business. And I feel like this, for the past couple years, this hasn't just been this is the tale of 2 bills, this legislative session. But for the past couple years, it's been the tale of 2 different types of people. You've got multinational corporations like Expedia that have their agenda that they want to push through, and they're very effective at it because they have the finances to hire lobbyists. Well, I don't, and the people that sent me here don't. So all we have is this hope that you'll listen to us here. And I know that hotels aren't going to provide the flexible jobs that Becky Groman's able to provide, nor the small business opportunities that were offered to people like me and Becky Groman. And I don't think that the hotel industry is serving the market. I think it's 2 totally different models. You've got this hotel industry, and then you've got guests, transient guests that want to stay in a home. They're serving 2 totally different types of customer, and the hotel industry isn't serving that customer. You've got short-term rental owners that are providing great economic opportunities, and I don't think the 2 should be regulated the same. I think there should be some minute differences between them. I like Keith's bill because he's really taken time to get to know what the challenges are of this type of business owner who is serving that type of transient guest. But we really like the clarification of the reasonable regulation. That's going to help us a lot because in our area, you talked a little bit about the difference between keeping it local. Well, Lake of the Ozarks has some great local government right now. They've voted in some pretty fantastic people. They don't have the hotels or the large businesses that we do in our area. The issue that we have, and you'll probably hear some examples of this, is that our local government tends to be a bit tribal, and the small business owner has less control. So, yeah, we do need some regulation, but we don't need all of the regulation. And also, I did find this for you, Mr. Meredith. There's a July 2006 Missouri Appellate Court decision called Mullen versus Silver Creek Condos. And it's file number 27333. And that is a case where the Missouri Appellate Court classified vacation rentals not as a business, but as residential property. That's just some reference for you. So we do need regulation, but we don't need interpretation by local governments of what's a business and what's not a business, what's commercial and what's not commercial. What I'm looking for from you guys is just a little bit of guidance for our local tribal governments so that they don't go too far awry in the creation of their ordinances. I think Keith's bill truly safeguards this industry without giving too much power to multinational corporations. And I don't know, but I think that this committee passed the Expedia bill out of this committee by a unanimous vote. And so all I'm asking is that you would strongly consider passing Keith's bill out because I believe it gives a voice to the people and it would give the same small measure of power to the people that Expedia has. Thank you very much.
Questions? Seeing none, thank you very much for the testimony and support.
Good evening. Thank you for the opportunity to speak. My name is Lance Mayfield. I've kind of become the poster child in Stone County for what we're talking about. I'm not going to belabor any of the points that Keith has made or Jeremy. Just give you some of my experience and kind of what's going on. I live in the middle of the Mark Twain National Forest. I don't live in Branson, but on Table Rock Lake is where I purchased a home in 2014. And much like Senator Meredith said, these things, or Representative Meredith, these were not so common even in 2014, I found out, because we as a family, much like the commissioner had mentioned, when we take a family vacation, we started researching VRBO like in Destin, Florida, and every other place we've stayed as a family. Again, when I travel on business, I'm a farmer's insurance agent, have been for 30 years. I'm a realtor, sort of new in that business, but I have other business interests as well. When I travel for business, I stay in hotels. When I travel for family vacations, we do VRBO. And that's when I first got the bug about, I'd like to do that myself. I think that's a great opportunity with my family and also to create revenue for a place that we might want on Table Rock Lake. So we sought out a property at Table Rock Lake that ironically, within 1/4 mile of where the home is, has 115.5 acres of woods within that 1/4 mile. So there's a homeowners association there that does not address anything except the water we use and how much we pay for it. So when I sought out this property, the first things I started thinking about was, okay, can I do this? Back to the point the commissioner made, this property had been vacant for 2 years. I was making mortgage payments on it, living in Las Vegas because you got a job transfer. The people in the community couldn't afford to buy the $250,000 log home. So it sat there empty, rotting away. So I saw it as an opportunity myself and an investment in that community in Stone County, which is near Blue Eye. So I picked the property because it's what I liked. It made sense to me if I was coming there as a vacation rental owner that there wasn't a lot of people around. It was opposite of a lot of the things we're talking about. The realtor said he had no knowledge of anything that would keep me from having a vacation rental property. He was a prince of a man and worked hard to try to find that information out. He provided me the name of the homeowners association man. I talked to him, and he said, no, we regulate water and make sure everybody pays their water bill so people can flush their toilet and drink, and that we don't really do anything else. At the closing table, I said, is there any reason that anybody knows that I can't do this vacation rental property? After all, I am titling it in Ozark Country Cabins, LLC. It's my full intent for my family to use this property and to also use it as a vacation rental property. Nobody could come up with a reason. Prior to that, I Googled everything I knew how to Google about if this was an issue. So after 3.5 years, no problem. A mile away, there became a problem with a double-wide mobile home rented for $135 a night. Got a lot of partiers in it and became a problem in the area, if you will. So they addressed him, and then I became one of those, oh, by the way, that guy does it too. So I got a letter from Stone County that said I was in violation of county ordinance. I had no knowledge of any county ordinance. Nobody else had made me aware of any county ordinances I was in violation of. So in their information, they said they had a special conditional use permit that if you met certain criteria, then that permit would be provided. So I went to the Planning and Zoning Committee and presented my case that all 10 points of the criteria that I had met. I was voted down, and it was just a no vote with no explanation. So I got a letter that said that the vote was no, and I couldn't operate this vacation rental property. So I sent him a letter and asked him why. And he said, because the Planning and Zoning Board voted no. So there was an appeal process. So at this point, I hired an attorney because I felt like, well, I thought I was doing my due diligence. I had provided the information accurately as they asked for it. I met all 10 points of their criteria, went to the appeal process with an attorney, got voted no again, and they came up with 2 reasons that wasn't part of the 10 points of criteria that was a reason they didn't allow it. Drawing your attention back to commercial, just to give you an example, my home in Stone County is my home that I also use. We have family and friends that use it, and then we also rent it out for revenue. It's not insured as a commercial business because there is a very specific residential vacation rental owner policy that addresses it because it's not commercial. It's not a gas station, and it's not a restaurant, it's not a motel. It's not a commercial risk when it comes to insurance. It also wasn't listed in real estate as commercial property. It's a residence. It's also not taxed by the very county that I pay taxes in as anything that is commercial. So it is purely a residential property that I happen to create revenue from. Just like if you all were out on spring break and you were working from that home, you're making money doing your job, working from that home, making phone calls or being on the internet. You could be selling Avon or whatever other products. So is it a business? Yes, it's a business. Is it commercial? No, it's not commercial in my insurance opinion with 30 years experience and my real estate experience. It's clearly not commercial. So I just present to you that this is what's happened to me. I now have 2 lawyers that's working with Stone County to try to figure out what exactly are my options because they've come up with 2 reasons they didn't have before as to why I can't have a vacation rental property. In my hearings, people came to testify against what we do, and they used an example of the weekend before there were 5 vehicles at my vacation rental property, and that was part of the problem. As Representative Frederick mentioned earlier, there's all kinds of people that go to my property. That weekend happened to be my daughter at our property. She does an online fitness something. She coaches people. And she had a meeting with 5 of her friends there to do a little weekend getaway with them. Nobody paid me any rental. A month before that, there was a family in my hometown that mom had cancer. It was going to be their last and only family vacation. I give it to them. I didn't make any money off of it. And there's a lady that cleans for me, just like Jeremy was talking about, that works in the marina industry during the summer. She cleans our cabin during the winter. So she has a full-time job between 2 jobs. So, again, I don't want to belabor all the points everybody else is going to make. I just want to give you some thoughts about my experience and how frustrating that's been when I feel like I've gone to a community to invest in that community, and ironically, the people at the Planning and Zoning Board, mostly ladies, said, your property's the kind of property we look for when we go on vacation to. I'd entertain any of your questions.
Questions? Seeing none, thank you very much for the testimony and support. Be sure to file witness form, proceed when ready.
Thank you. My name is Tyann Marsink. I've been in the vacation rental industry since 2007, so I'm going on 11 years now. 5 years ago, attending a HomeAway Summit, part of the statistics they gave was only 30% of United States citizens even realized that a vacation rental was an option when they traveled. That was 5 years ago. Vacation rentals was considered alternative accommodations. It is no longer considered alternative accommodations. I know many people who specifically will only stay in an area where this type of accommodation is available. It's not just tourism areas. I myself have 5 properties. 2 of them are in Branson. I host 3-generation families quite frequently. That's my main guest. And 3-generation families is not something a hotel can host very easily either. Grandma, grandpa, kids, spouses, and their kids as well. My other properties are a small 2-bedroom house in Union, Missouri, which is a bedroom community of St. Louis. And I actually did have tourism this week. They were visiting Merrimack Caverns over just down I-44. My other main guests are actually people from all over the United States coming to Union to compete at Purina Farms Event Center. And they'd rather not stay in a hotel with their 6 dogs. And I'm okay with that. I mean, they're there to compete. My other 2 properties I just purchased, I'm renovating, are in Marthasville, Missouri, a little tiny community of 1,100 people. I am a little bit proud of myself. I feel like I've lit a fire under a community who's been pretty downtrodden. And this community is extremely excited to have me there, sinking money into their area and developing the old Marthasville Bank that was built pre-1900 and the little house next to it, and bringing more tourism and also a place for people to stay when they're here for weddings. So it's not just tourism that brings people that wants to stay in a house. It's just daily life as well. I have people who have contacted me. They're traveling nurses. They only have a 13-week stint in their area. Or they've coming to adopt a child, and they need to be in the area for 2 weeks. And a home is where they'd like to be with that baby. What I love about this particular bill is it establishes these rentals as residential classification because it's still being used as residential uses. I completely agree with the sales and tourism tax, and I have had my guests pay sales and tourism tax since 2007, contribute to Missouri state economy, and they're using the roads, they're using the emergency services. I make sure my guests pay their part of that as well. And then places rental representation on the advisory boards so that we do have representation that where these taxes, are going to. Right. Thank you.
Questions? Seeing none, thank you very much for the testimony and support. Proceed when ready.
Hi, my name is Lana Camp Jessup, and I have a 4-family apartment in the Cherokee neighborhood that my husband and I have renovated ourselves. We bought this apartment building in 2014, and the original intention was to have them as long-term rentals. We were long-term landlords for a couple of years and came to find out that it was, I guess, for lack of any better terms, it was much harder to evict a tenant if they were a problem than it would be with Airbnb, with what we do right now. Not that we want to evict anybody, but when there are problems, it could take several months to get somebody out who have no regulations that Airbnb actually covers, and this is something that I'm actually very happy about. Statistically, I've had over 99% of my guests be great guests. They even make their bed when they leave, which is wonderful. In addition to the fact that being short-term rentals, they contribute to the economy a whole bunch more than any of the long-term rentals that we would have had with the rent that we receive and then with the money that they put out for the restaurants that they go to and the places that they shop at and the places they come to visit in St. Louis. And I support this bill. I'm happy to pay whatever regulations that we need or taxes that we need to pay on top of what we have already been paying. But I just want to mention that I am fully sustainable now. I don't have to have my second job in order to support ourselves. If we were to do this as long-term rentals, we were barely able to pay our bills, and now we can happily do that and help contribute to our community a lot better. And what else was it? I forgot what I was going to say. Oh no, I get a little nervous. I think this is not a hotel. I consider this to be like, well, they're short-term rentals. It's just like in my situation, they're just like apartments, but we just have a shorter term of people that come in. I go back there. I was able to get a guy out because he had a party against the rules, which Airbnb can put in place, and I got him out that night, which if I had a long-term rental, it would have been much more difficult to get someone out who is a habitual partier, and that's not what we want. We want people to come in here and enjoy themselves and visit a very walkable and community-oriented neighborhood and be able to see the wonderful places that St. Louis has to offer. So I thank you for the opportunity to be able to say something about this.
Thank you. Questions? Seeing none, thank you very much for the testimony and support. May proceed when ready.
Howdy. I'm Brad from Branson, Missouri. I did dress up. I apologize. I don't have a coat and tie on like everybody else. I support Keith's bill because I've gone through some of the same things. I've got one property in Branson where I had to spend $22,000 on reasonable regulations just to operate it as a vacation rental. I have another property in Taney County, same kind of thing. I spent $14,000 on fire sprinklers because that's what they said I had to do. I play by the rules. All my properties pay their taxes. So I support what he's doing here, and I won't go over all the same things that they all said. I don't know a lot of them that just spoke, but I appreciate what they said, and I support the bill.
Questions? Seeing none, thank you very much for the testimony and support. Be sure to fill out a witness form and proceed when ready.
Thank you. My name is Joette Reedy, and I am from Franklin County in the small town of Washington, Missouri. I have been involved as both a guest or a transient renter, which doesn't sound like something I am, but I guess that would apply. And I am also a homeowner that has listed and has provided home sharing opportunities for people passing through our community. It's very important to tourism, especially in small towns like Washington, because when we do have the festivals and the bigger weddings, we need beds for these people to sleep in. And sometimes there's nothing available, not only in our area, but as far out as Pacific and Eureka, Sullivan, each way, especially for winery season, for the festivals that they have in Herman and Augusta. More beds are needed. And our town recently spent $12,000 on a feasibility study. And that study came back to say that if a hotel came in providing 100 rooms, it would only be 57% occupied. And that tells me that we do need beds, but we don't have the support to warrant a chain, a hotel, to come in. Not yet. But by offering the beds through home sharing and through short-term rentals to our transient guests, we someday could support a hotel. And hopefully sooner rather than later, because we work hard with our tourism department and our economic development departments and our downtown Washington board to bring in outsiders, to bring in tourists. A lot of times when people come in, they're not looking for a hotel, and they certainly don't want to stay above a bar downtown. That's where my daughter would like to stay. That's where a lot of people love to stay. But the guests that have stayed in my home have specifically sought out a quiet environment in a neighborhood away from the action. And that's where I live. I live in one of the nicest subdivisions in Washington. My guests have shown up in Mercedes and Jaguars. They've brought a lot nicer clientele than my own kids brought in when they still lived at home. So we don't have to worry about the kind of people that we're going to bring in, because I wouldn't want to bring someone into my home that my neighbors wouldn't want in my neighborhood. It's my home that I'm sharing with them. So a few of our neighbors, the very, very vocal minority, took a stand when they found out that I was doing this. And for months, they didn't even know I was doing it. I had nothing to hide. I wasn't trying to do it behind any closed doors. But they just didn't know. Because when a car would drive up my driveway, it could have been one of my kids, or a cousin, or a friend coming in for the weekend. But when they did find out, they got scared. They were worried about the what-ifs, the slippery slope. They were worried because they read on the internet what could happen with these transient guests. So they formed an opposition, and they presented it, and I am no longer able to offer my bedrooms to guests as they come through our town. I hope that that changes. I hope that the state of Missouri passes this bill. I hope that it takes the power away from scared neighbors, people that are scared just because they're scared of the unknown, and it gives the power to the homeowners to share their home with guests. The biggest thing is that we need to trust homeowners that they're not going to share their home with someone that they wouldn't want to share their neighborhood with.
So Washington currently bans them?
My neighborhood has decided not.
Your HOA decided?
Yes, the homeowners association. And the shame of it is, when they brought this to the Planning and Zoning Committee, there were a lot of neighbors that were in favor of it. But they didn't show up because, sure, go for it. I think it's great. We stay in Airbnbs all the time. You know, but it was the ones that were so adamant to stop it. And they're the ones that generally want to stop anything that they aren't familiar with. So, yeah.
I was just asking because Washington Town and Country Fair is August 3rd. I was looking for a place to stay.
You can stay at my house. I can't charge you any money, but you are welcome to stay.
Even better.
I have a beautiful home to share, and you're welcome. And our town is wonderful. So, yeah. Yeah.
Questions? Thank you very much for the testimony and support.
Thank you.
May proceed when ready.
Hi, my name's Laura Martin. This is my third time here, so hopefully you remember me this time. I'm here to support Representative Frederick's bill, and I would first just like to thank him for including the homeowners and our commissioner from Camden County that you saw, and many folks in our area in Branson that are intimately acquainted with this and affected by this. I really do appreciate the opportunity to speak into the bill. And I will say to some of your comments, Representative Meredith, that being from the Lake of the Ozarks, we are in a really good situation. And honestly, the reason I'm here is to support these people, because I don't need a bill right now. Okay, we're in a good situation. We have worked really, really hard to elect officials that are very supportive of what we're doing. So I'm not going to lie about that, but I am concerned that may not always be the case, and that some of our cohorts down in Branson and other parts of the country, or rather the state, are experiencing very egregious situations. And I'm not totally selfish, so I'm here for them. But one of the things that has frustrated me during this process is this idea of commercial versus residential. And, you know, and then we've used the word business. With the previous legislation, when we were here, there was a lot of talk about leveling the playing field. And that's frustrating to me because I don't feel like it's the position and the place of the government to come in and try to be leveling the playing field. I think that is a market function, and that's something that, should happen in that way. But one of the frustrating things is that the idea that vacation homeowners should be subject to commercial regulation, and for public health and safety and those kind of reasons. And one of the things that I've thought about for me is for public health and safety, do you think it's healthier to eat in your own home or eat out all the time? Well, I think it's healthier to eat, at home and cook for myself. And I've talked both times I've been here about my son who has Down syndrome, and he has very, very specific dietary needs that we have to have for him. And so when we travel, we have to have a kitchen, and we have to have a kitchen, to travel. There's no other way for us to travel. So my question is, why aren't we requiring all hotels to have a kitchen? I mean, it would be ADA compliant for me. That would make them and my son be able to stay in that hotel, but we don't do that because that's preposterous. A hotel is not a home, and a home is not a hotel. And I own a vacation home. It's a home. It has a kitchen. And I think my concern is just this idea that we should level the playing field and regulate in our communities homes like hotels. And I think that Representative Frederick's bill goes a long way in trying to address that, because his bill specifically says that we are residences. We are residences. We remain residences. It's being used as a residential use. And yes, we will pay sales tax. I pay sales tax. I pay lodging tax. It's important to me that somehow, though, in paying that we not be called commercial. that we are creating and recognizing here that we are creating some kind of hybrid that does not currently exist in state statute. And so that is why, for one reason, that our folks in Camden County have not believed, like our Mid-County Fire District, that they can come in and regulate us any differently than a house already used as a residence. And that's what Representative Frederick's bill says. If you want to put regulations in on houses, that's fine, but and on vacation rentals, but they're residences, and so it has to apply to all houses. So if you've got an elevator in your home, and you use it as a vacation rental, and it needs to be inspected once a year, everybody that has an elevator in their home needs their elevator inspected once a year, because people who use their home all the time should be protected in the same way that a vacation homeowner and their people that are using their house are protected. Anyway, I will just close, with a couple other thoughts. The specific improvements that are in this bill, one is the representation on the tourism board. At the Lake of the Ozarks, we do not have representation. I pay tourism taxes. I paid over, thousands and thousands of dollars in tourism taxes. They have not been friendly to us in my area, and taxation without representation should not be allowed. Secondly, another area of improvement in his bill is contact information with the facilitation platforms. And I won't take a lot of your time up with this, but you need to understand that facilitation platforms right now do not give you the contact information of the guests prior to money being exchanged, because they are so worried about collecting their service fees and all of the money that they want to have that they will not let you. And once you approve the rental of this person that you can't talk to, you can't call them on the phone, you cannot email with them privately, you have to message with them over this platform, then you get the contact information once money has been exchanged. Well, if you realize that person is not a good renter because you're trying to protect your neighborhood, I don't allow fraternities and sororities. I want to talk to people and make sure that these people are conducive to my neighborhood. Then if I cancel that, I get beamed down all the way on those search platforms on Expedia, VRBO, Airbnb. That's not okay. We need consumer protections to make sure there aren't scams, people that aren't really actual people renting, people that don't actually own the homes renting. So you need to be able to have communication, and Representative Frederick's bill has that in there as well. So,
thank you. Questions? Thank you very much for the testimony and support.
Hi, my name is Stacy Shore, and I'm here to support Representative Frederick's bill. Just a couple of things that differentiate the bills. The residential designation is super important to us at Lake of the Ozarks. To your point, Representative Meredith, the transient thing, I understand, like within St. Louis or where I grew up in a little town called Marshfield, if I had a transient or a person I didn't recognize coming in and out of the house next door to me, it may look different than what it looks to us. I live on the lake and have for over 20 years. So to have people that are unrecognizable, just last week there was a big bass tournament. And there were people in and out of my neighbor's house all week that were fishing. They had their boats tied up, their boats weren't in the dock, they're transient, unrecognizable. So to your point, to have something different that maybe is just applicable to the lake, whereas there are different bills that would be applicable to the city or more, neighborhoods that look different. We really like the designation or that idea that's been tossed around or volleyed around. But the residential designation is so important, because at which point we're considered commercial because there are transient guests. It becomes very, very dangerous in the perspective of taxation and also regulation. We're here protecting the moms and pops, not the guys that necessarily own 8 or 10 vacation rentals, but for the literally 80% of our market that is a mom and pop type of rental, that they rent 6 to 10 to 12 weeks a year to help defray costs. That's the majority of what our rentals look like at Lake of the Ozarks. And if we lose that, if the regulations or the interpretation, or if they're considered commercial or a business, the use is residential. It's no different than a long-term rental. So if that becomes fragmented, we are in jeopardy. So we really do appreciate that. We appreciate Representative Frederick's, the part of the bill that allows us to have representation on the tourism boards if we're going to pay taxes. We appreciate that because there's no provision for that now. That's a huge improvement. And also allowing the vetting, the part about these facilitation platforms that they're cutting off the ability of a renter and an owner from making a connection, in order to gain their facilitation fee prior to that connection. To allow that consumer protection is so important because it allows owners to protect their neighborhoods, and it allows that renter to know a house actually really does exist. So it protects from the fraud that we are seeing go on now, that's been a disconnection as Expedia's platform has changed VRBO. So there's some really great changes that we're very grateful for, and that's why I'm in support of Representative Frederick's bill. Thank you so much.
Questions? Representative Taylor.
To inquire.
Proceed.
So the first point you made was about the residential. Can you tell me where that specifically outlines? I'm just curious because you said it's different in the other bill. Where's that specifically at in this one?
As far as his, and I'm sorry, I don't have the bill in front of me, the residential use provision and the language in his bill that actually designates. And to your point, the thing that we're worried about is with the sales tax, creating a portal, because we would become a merchant by state statute if you collect sales tax, and it's all over both bills, which we're fine with that. But the language in Representative Frederick's bill actually designates that we would not be regulated differently than any house in a residential subdivision would. You can't pluck us out because we've rented for 3 weeks a year and regulate us or tax us differently than our neighbors. So I can look at it back there, Representative Taylor, and then get back with you after the hearing
Okay,
and
because
discuss
I'm
that with
looking
you.
at the definitions of residential dwelling and residential dwelling rental,
Mhm.
and they're the exact same in both bills. So that's why I'm just curious.
It's not found in the definition.
Oh, it's not in the definition.
It's not in the definition.
Where's
It's
it?
actually,
I'm sorry. Maybe
and I
it's a question for
apologize, I
the
don't have it in
sponsor.
front of me, so it's not in the definitions. It's
Okay.
actually further down in the bill.
Okay. Yeah, please. I'm just curious where that's at.
It's actually in the section that describes commercial versus residential. And I think the individual who
where?
drafted it is here too, so maybe she could point out to me the area of the bill where I can just say this, that in this bill, these residential dwelling rentals are considered 100% of the time to be taxed for purposes of property tax as residential. But now they're going to pay the sales tax, they're going to pay the lodging tax, the tourism tax. But for purposes of property tax, they're to be considered residential, just like the Uber cars are always considered to be private cars, not commercial cars.
Okay. Well, I'd still like to know where the difference is on the residential dwelling. I'm just curious. So if we could look at that later or
I guess
talk
that
about
would
that.
we would need to look at the other bill too to see, is that what you're getting at, is the difference between the two?
Yeah,
or?
yeah.
Okay.
Because she said that and I was asking her about her first point. She said that it specifically listed residential dwelling. There's a difference in your bill compared to her bill. That's why I was curious.
Well, and
Where you at?
this is page 13 of the bill, number 5 on that page. Residential dwelling rentals as defined under section 67.5140.
It is under the definition of residential property on page 12, line 18. Residential property, and then it goes on to describe residential property. And then it describes in G on page 13, line 5, it says residential dwelling rentals are considered residential property.
Yeah, which is that's the definition that's in her language as well.
And again, that goes back to use. I mean, the use of the property is what we want to focus on, because if it can be and I don't have her bill in front of me, but that provision is incredibly important to us as embedded in Representative Frederick's bill.
Okay.
So again, just the vacation rental owners and people that have come together and just trying to address that, it's a huge improvement.
Okay. Thank you.
Thank you.
Further questions? Representative Raber.
Inquire.
Proceed.
I'm curious about the additional vetting that you're
Yes.
talking about through, because I've used VRBO many, many times, and we've communicated back and forth on email before any money exchanges hands.
The platform has changed, and I mean, most recently, and honestly, I don't use VRBO to rent my rental, people in the back, but in just advocating and being a part of so many people that are, I mean, that question, what's happened is they've changed the platform. So if you, in order to collect a facilitation fee, now they collect the fee and then you can actually talk to the renter. So this is a new, Expedia acquired VRBO in December of 2015. And since then, the platform is radically being changed. And so that's something that's just important that we see. And I don't know if it happens, and it's evolving, but the point that we have is, in order for us to carefully protect people in the neighborhoods that live and use this, or that are worried about vacation rentals, if we're treated like a hotel and we can't make that connection with the potential renter and tell them how many stairs we have or how many slips are in our boat dock, if that disconnection is made, then it jeopardizes the owners all around us also, because we don't want partiers in our houses. We don't want people that would not care for the neighborhood.
Yeah, I get all that. This most recent one I did was just in December. And I can't imagine them eliminating being able to ask questions like you said, how many stairs, and we went to Disneyland, how far away is Disneyland, those kind of things. And we communicated about those kind of things several times before. I wouldn't have made a decision without knowing those things.
Right.
So,
and that's true. That's how we feel also every time we rent, and we've rented for the last 13 years in the same area. I always want to ask questions. I mean, I want to know, I have specific questions based on bedrooms, how many people,
yeah,
stairs.
but it's been my experience that VRBO does allow that communication.
Right. And just know that the platform, and many of the owners behind me can tell you too, it's radically changing and has changed even in the last several months. So. Thank you.
Representative Robert, you complete. Further questions? Seeing none, thank you very much. Further testimony and support? Seeing none, any in opposition? Proceed when ready.
Mr. Chairman, members of the committee, Organ Schlemmer on behalf of the Missouri Hotel and Lodging Association. My comments are very similar to those. Actually, some of those comments are similar to those that I've made on Representative Anderson's bill, although I think her bill probably sets out a relatively clear framework for trying to delineate between those folks. I think we heard a lot today about those folks who own their home and try to rent it out versus those folks who purchase homes solely for the purpose of renting them out for a short-term stay. I think there's a big difference. A person who owns 5 different homes, all within 2 miles of where they live, those are not vacation homes. Nobody has 5 vacation homes within 2 miles of where they live and never spends one night in any of those homes. That is a business. They are purchasing those homes solely for the purpose of renting those out and paying sales tax. Nearly 100% of the nights that are rented in those homes are subject to a sales tax. A sales tax is a commercial purpose. The idea that a person can stay at home and they can sell Avon out of that and we don't tax that as commercial. Think of all of the residential homes, at least in my town, that you see that are converted to Edward Jones or insurance agencies and so forth. We would never allow those types of businesses in our single-family dwelling zoned 1, R1 areas. I think what we're talking about here is saying, look, I need, since I'm the exception in my area, I need the statute to protect me against everybody else that's in the neighborhood. If you think about, I think Doc Frederick said this early on, is maybe we can only make this for the Lake of the Ozarks or for Table Rock. Actually, Lake of the Ozarks is a lot different than Table Rock. We represent hoteliers in both of those areas, and they talk about the differences. And those two are different than Poplar Bluff. They may need a separate law. That's different than Cape Girardeau or St. Genevieve or Ladue or City of Kansas City or in the Plaza area. There is not one law that is going to fit the entire state of Missouri, hence local control. If you have more local control and more elasticity for local control, then you can fit all of these different types of scenarios. But trying to take a piece of legislation like this and apply it to all communities throughout the state simply does not work. A couple other points about this is the business license tax. Communities use business license taxes on hotels. That's how they tax rooms instead of using transient guest tax. Yet this would exempt people who are renting their homes out from that type of transient guest tax. Finally, it changes from 5 to 10 rooms in hotels. A 10-bedroom home that is solely used for renting out is much closer to a hotel than a 5-room. That's a major expansion. In fact, you probably have a lot of bed and breakfasts that are currently regulated today that are not 10 bedrooms, and this would end up exempting them as well. So those are my brief remarks.
Questions? Seeing none, thank you very much for the testimony in opposition. Sure to follow witness form. Proceed when ready.
Good evening, Mr. Chairman, members of the committee. My name is Richard Sheets. I'm with the Missouri Municipal League, and we certainly concur with the previous witness on those points. Communities are different, and we have our zoning laws that take those in consideration. I think one of the main points of this bill, we appreciate the sponsor putting in the bill that these home rentals collect the local transient tax. Cities right now regulate home businesses. There's a number of provisions for home businesses in communities. They have a home occupation license for accountants, and they're these business licenses they acquire to be sure that they are complying with the ordinances and that those residential units or homes are being maintained and integrity is still maintained as a residential dwelling. And also to be sure that they're paying applicable taxes. How a city would know someone is paying or is liable for a transient guest tax is because of their business license. The city collects that. The state doesn't collect that. They use the business license to identify those businesses that owe particular taxes. In this case, would be for transient guest tax. I'll try to answer any questions I can.
Questions? Representative Meredith, proceed.
So just to clarify, this bill would take away the ability to require a business license.
It does. The very last section, it would, and then would.
So we had a neighborhood just outside of my district that had a very well-attended meeting. Probably 200 people showed up because they were upset about one property that was being used as a vacation rental that was causing all kinds of problems. Their solution to that, or at least the solution that the local electeds seemed to be preferring, was to start requiring business licenses for these so that they could use that as a hammer also if repeated violations started happening, that they could then remove a license to act as this business. Is that a concern you've got?
Well,
taking
and
that's
away? That's one tool. I mean, the business license, if a particular business has a problem with discharging waste, or just a bunch of issues, and that's how they can mitigate that situation by pulling the business license. And the state of Missouri uses local business license also to ensure that businesses are paying state taxes. And there's a statute saying that cities have to get the applicant has to get a no tax statement from the state of Missouri. So its primary use is to be sure they're complying with the ordinances of the city.
Yeah, it sort of gives them an ability to actually make sure they're complying.
Yes, sir.
So I'm a little worried about taking that ability away as well.
Right.
Thanks.
Questions? Seeing none, thank you very much. For the testimony in opposition. Seeing none, any for informational purposes? Seeing none, Representative, any brief closing remarks?
I will keep my closing remarks to appreciation for the committee for being here late after a late adjournment and for the committee chairman's willingness to hear this bill with an extra meeting. I appreciate it very much.
Thank you. That'll conclude the public hearing on House Bill 2569. Madam Secretary, can you please call the roll?
Representative Cornejo.
Present.
Matthews. Carpenter. Anderson. Arthur. Basie. Cross. Evans. McCreary. Meredith. Raber. Schroer. Taylor.
All right, quorum having been established, we will now move into executive session. I move that the Committee on General Laws vote to do pass House Bill 1882. As you may recall, this is Representative Trent's bill that we heard last week regarding battery recycling, and it was actually voted off the House floor last week as an amendment onto my House Bill 1832. Any discussion on House Bill 1882? Seeing none, I renew my motion that the Committee on General Laws vote to do pass House Bill 1882. Madam Secretary, please call the roll.
Representative Cornejo.
Aye.
Matthews. Carpenter. Anderson. Arthur. Basie. Cross. Evans. McCreary. Meredith. Raber. Schroer. Taylor.
By your vote of 11 yes, 0 no, you voted to do pass House Bill 1882. Moving on, 1993. I move that the Committee on General Laws vote to do pass House Bill 1993. As you may recall, this is Representative Spencer's bill that we heard just last week dealing with crime and inspection report towing. Any discussion on House Bill 1993? Seeing none, I renew my motion that the Committee on General Laws vote to do pass House Bill 1993. Madam Secretary, please call the roll.
Representative Cornejo.
Aye.
Matthews. Carpenter. Anderson. Arthur. Basie. Cross. Evans. McCreary. Meredith. Raber. Schroer. Taylor.
By your vote of 11 yes, 0 no, you voted to do pass House Bill 1993. Moving on to 2302. I move that the Committee on General Laws vote to do pass House Bill 2302. As you may recall, this is Representative McGee's bill that we heard regarding the unlawful use of a weapon, also called Blair's Law. There was a House Committee substitute distributed ending in 03C, and I move for its adoption. Speaking with Representative McGee, I think you just said that this reclassifies it as a Class D felony. Is that, am I remember correct? And I believe this version was what was a draft of this bill. This committee substitute was distributed prior to the hearing on this, and so that's what the testimony that we heard during the public hearing was directed towards the committee substitute. Yeah, Class D felony. Discussion on the House Committee substitute for House Bill 2302. Representative McCreary. That has been distributed, or is that what you're doing?
Yeah, that's what I'm doing right now. More and more of a bipartisan issue. We're seeing codes about
Representative McCreary has moved for the adoption of House Committee Amendment number 1. Discussion on House Committee Amendment number 1. Representative Taylor.
Just to make a statement.
Please.
Representative McQuarrie and I kind of discussed this in committee the other day, and I asked to have a conversation about it, and we haven't had that opportunity yet. I think Blair's Law is bipartisan. While I agree that there are some bipartisan support for this, I don't know that you're going to get the same support for it as you would with Blair's Law, and I just have a feeling that it's going to bring Blair's Law down and muddy it up. And in my opinion, I think we should leave Blair's Law clean and move it forward as is and be able to pass it, where this bill, I think, would get bogged down a little bit, just having to move it through the process and haven't really, debated it much. So that's just my opinion.
Representative Shore.
Speak on the amendment.
Proceed.
I kind of echo Representative Taylor's sentiments on this. I just received it seconds ago, even though we've been in here for a couple hours. So looking over a 5-page amendment and putting it on something that is incredibly bipartisan, incredibly common sense, I would ask for maybe this to be discussed in the interim before Blair's Law gets to the floor, to see if we can work on it in a similar fashion that we worked on Representative Lichtenegger's and Representative McCreary's bill that was in here a couple weeks ago. So for that reason, not being familiar with this whatsoever, and hoping that we can actually have a discussion on it rather than a 3-minute discussion before we put it on a very common sense bill that I think needs to get done. And you heard the witnesses say that this is something that had been through the process year after year after year. I think it's time we get it on the floor and see if we can put anything else onto it that the entire body will be in favor of. Thank you.
Further discussion, Representative Carpenter. Proceed. Does the amendment maker yield? Proceed.
Thank you. To clarify, you offered this previously, right?
Yep, we spent a long time. This is the exact same language that we debated.
Right, so that's been weeks ago now. Okay. To be deemed an extreme risk, and for there to be a judge would have to be involved with that. Is that right? Yeah. Right. And then in that situation, what happens to the firearm in that situation?
If there's reasonable cause to believe that the defendant poses a risk to himself or herself, they can court can take that order, and if they find clear and convincing evidence, then they can take weapon away from the person.
Right. So the judge would have to agree with the determination that a person is a, quote, extreme risk. Is that correct? Yeah. Okay.
Like for, people like a husband and wife.
Yeah. Well, it seems to me that it makes a lot of sense that if a judge has deemed somebody a, quote, extreme risk, that the temporary removal of firearms from that person's possession makes a lot of sense. I'm not sure what the concern with your amendment is, to be honest. I've had a lot of time to look at it, and also I think it makes a lot of common sense that, again, if a judge finds somebody to be a extreme risk and issues an extreme risk protection order, that would be a good situation to remove firearms. And so I support your amendment. Very much hope that. Thank you.
Further discussion. Seeing none, Representative McCreary has renewed her motion to adopt House Committee Amendment Number 1. All those in favor, please signify by saying aye. All opposed, please say no. No. The noes have it. You have failed to adopt House Committee Amendment Number 1. Further discussion on House Committee Substitute for House Bill 2302. Seeing none, I renew my motion to adopt House Committee Substitute for House Bill 2302. All those in favor, please signify by saying aye. All opposed, please say no. The ayes have it. You have adopted House Committee Substitute for House Bill 2302. Further discussion. Seeing none, I renew my motion to Committee on General Laws vote to do pass House Committee Substitute for House Bill 2302. Madam Secretary, please call the roll.
Representative Cornejo.
Aye.
Matthews. Carpenter. Anderson. Arthur. Basie. Cross. Evans. McCreary. Meredith. Raber. Schroer. Taylor. Yes, Taylor.
I was waiting for it. I didn't hear it.
Taylor.
By a vote of 11 yes, 0 no, you have voted to do pass House Committee Substitute for House Bill 2302. Moving on to House Bill 2413. I move that the Committee on General Laws vote to do pass House Bill 2413. As you may recall, this is Representative Schroer's bill. I'll let him have the floor.
And again, 03H, and I move for its adoption.
Representative Schroer has moved for the adoption of House Committee Amendment Number 1. Representative Schroer.
So after a lot of discussion with the interested parties, EMS, fire, police, kind of took the version that we had previously. Don't want to necessarily say dumb it down, but I know attorneys can get a little too wordy. So initially we tried to comply with the U.S. Supreme Court decision indicating that a warrant or consent must be present for blood draws to comply with the Fourth Amendment. So we amended it and indicated that they may, with the consent of the patient or a warrant issued by court of competent jurisdiction, took out the three kind of convoluted prongs that we spent a lot of the discussion on the other day, and then left the rest as is. So with that, I'll entertain any questions.
Discussion on House Committee Amendment Number 1. Seeing none, Representative Schroer has renewed his motion to adopt House Committee Amendment Number 1. All those in favor, please signify by saying aye. All opposed, please say no. The ayes have it. You have adopted House Committee Amendment Number 1. Further discussion on House Bill 2413 as amended. Seeing none, I make a motion that we take the House Committee Amendment, roll it into a new House Committee Substitute, and adopt that new House Committee Substitute. Discussion on that motion. Seeing none, I renew my motion to take the House Committee Amendment Number 1, roll it into a new House Committee Substitute, and adopt that new House Committee Substitute. All those in favor, please signify by saying aye. All opposed, please say no. The ayes have it. You have adopted House Committee Substitute for House Bill 2413. Further discussion. Seeing none, I renew my motion that the House Committee on General Laws vote to do pass House Committee Substitute for House Bill 2413. Madam Secretary, please call the roll.
Representatives Cornejo.
Aye.
Matthews. Carpenter. Anderson. Arthur. Basie. Cross. Evans. McCreary. Meredith. Raber. Schroer. Taylor.
By a vote of 11 yes, 0 no, you voted to do pass House Committee Substitute for House Bill 2413. Moving on to Senate Bill 581. I make a motion that the Committee on General Laws vote to do pass Senate Bill 581. As you may recall, this is Senator Leibla's bill dealing with the landlord-tenant deposits and the separate trust accounts. I do have an amendment ending in 03H. It has been distributed, and I move for its adoption. Just to be clear, you may have two different copies of the amendment. 03H is the updated one, and the one I've moved for the House Committee Amendment Number 1. So I know I've talked with some of you about this amendment. Give you a little committee some background. Back in 2014, the legislature passed legislation dealing with trial de novos and landlord-tenant cases. Recently, in just the most recent past few months, there has been a state Supreme Court case that has come down that basically said before the law in 2014 was passed, landlord-tenant cases, at the initial trial, you did not have a right to a jury trial. When you did the trial de novo, if you took a trial de novo option, then at that trial de novo, you then had the option to have a jury trial. But when legislation was passed in 2014 to take away the trial de novo option, the Supreme Court in the past few months said obviously the legislature was not trying to take away the right to jury trial because that would make the bill unconstitutional. So therefore what the legislature obviously meant was that everybody in the initial court case has a right to a jury trial. As you can imagine, there are landlord-tenant cases, hundreds filed in every single state courthouse across every single county. This is quickly jamming up the courts. And so what House Committee Amendment number 1 is seeking to do is just basically put all the statutes back into place, what was in place before the legislation that was passed in 2014, and put the trial de novo back into place. So without taking any discussion on House Committee Amendment number 1, Representative Evans.
To inquire.
Proceed.
Is this, were we talked about this the other day with Sam? Is this the law?
That sounds right.
Yeah, okay. I just wanted to, so you passed this in 2014. You didn't, but
No, I didn't.
Okay. All right. That's the same. Thank you.
Okay. Further discussion on House Committee Amendment number 1. Seeing none, I renew my motion to adopt House Committee Amendment number 1. All those in favor, please signify by saying aye. Aye. All opposed, please say no. The ayes have it. You have adopted House Committee Amendment number 1. Further discussion on Senate Bill 581 as amended. Seeing none, I make a motion to take the House Committee Amendment, roll it in a new House Committee substitute, and adopt that new House Committee substitute. All those in favor, please signify by saying aye. Aye. All opposed, please say no. The ayes have it. You have adopted House Committee substitute for Senate Bill 581. Further discussion. Representative Carpenter.
So I think the bill is okay, but one of the obviously the contentious parts is removing the requirement to keep the money separate, the security deposits separate. So, I think it makes sense to clarify whether there have to be multiple bank accounts or just one, that kind of thing, and clarify some of the trust account language. But I do think it makes sense to have the money kept separate if you're talking about at least if you're talking about a large provider, a large landlord, property corporation or something that has thousands of units. So I don't have an amendment drafted, but I'm going to offer one on the floor. Hope y'all will support it. That basically that allows the bill to stand for small landlords. But if you've got a group with millions of dollars of security deposits, I think it still makes sense, to me anyway, to have them keep that money in a separate bank account and not intermingle those funds with the regular funds. That way people's security deposits are protected. I understand if somebody rents out 2 or 3 houses, the idea that they have to have a separate bank account for a few $100 is probably unnecessary. But seems to me that it makes a lot more sense when you got millions of dollars of security deposits. So anyway, I'll offer that amendment on the floor and hope to get the committee support.
Thank you. Further discussion on House Committee substitute for Senate Bill 581. Seeing none, I renew my motion that the Committee on General Laws vote to pass House Committee substitute for Senate Bill 581. Madam Secretary, please call the roll.
Representative Cornejo.
Aye.
Matthews. Aye. Carpenter. No. Anderson. Aye. Arthur. No. Basie. Cross. Evans. Yes. McCreary. No. Meredith. No. Raber. Aye. Schroer. Aye. Taylor.
By a vote of 7 yes, 4 no, you have voted to pass House Committee substitute for Senate Bill 581. Moving on to Senate Bill 625. I make a motion that the Committee on General Laws vote to pass Senate Bill 625. As you may recall, this is Senator Searpoy's bill. It was basically the IBM fix, which is also similar to Representative Miller's bill that was heard multiple times in this committee. So, discussion on Senate Bill 625. Seeing none, I renew my motion that the Committee on General Laws vote to pass Senate Bill 625. Madam Secretary, please call the roll.
Representatives Cornejo.
Aye.
Matthews. Aye. Carpenter. Aye. Anderson. Aye. Arthur. Aye. Basie. Cross. Evans. Aye. McCreary. Aye. Meredith. Yes. Raber. Aye. Schroer. Aye. Taylor.
By your vote of 11 yes, 0 no, you voted to do pass Senate Bill 625. We're done with executive session. Just a friendly reminder, we are scheduled for our normal committee time and our normal place and room and time. We are adjourned.